Good evening, everybody. Efficient resolution of disputes is of extreme importance with respect to commercial transactions. Addressing the same in the agreement is all the more important. If that is not done, it creates a big risk towards both the parties. How is that to be done, and what is the role? First of all, what is the role of efficient dispute resolution clauses, and how is that to be done? That is what we are here to discuss about today. We have to discuss the same. We have with us Mr. Suman Jyoti Khaitan. Sir is a founder and managing partner at Suman Jyoti Khaitan and Company, as well as Khaitan Partners. So, without further ado, let's begin. Over to you, sir.
Well, thank you for giving me this opportunity and for helping me to give some experience which I've gained over the past few years to share. I don't know what the audience is. I believe they will be law students and people who are practicing law, or maybe those who may be like off counsel or working in a legal department. So whatever it is, I can just share some ideas. Now the topic is how to resolve disputes in the IPR mechanism, perhaps through mediation and arbitration, and not necessarily through the normal judicial process. Here, as you know, arbitration and mediation is constantly evolving, even in India, and worldwide, of course, it's been there for a long time. And it would be very helpful also if intellectual property disputes can also be resolved through this system to the extent it is practical. The only danger which arises is, as Supreme Court has also cautioned in Booz-Allen Hamilton case, that there are certain rights which accrue only between two individuals or between two private parties, and which will not affect any third party or the interests of state or the general public policy. To that extent, all these disputes can and should be resolved through mediation and arbitration, because it will not affect any other person. But there are, of course, certain matters which does affect a third party, including the broader public policy. So how do you handle that? Now, since we are speaking only of the IPR regime and not the other regime, where the court has said that arbitration is not the correct forum, for example, in criminal matters or in divorce or in testamentary proceedings, but that is not the subject today. Therefore, let us focus on the key elements or the key intellectual property areas. For example, if you take patent, of course, whether you are entitled to patent or not, only the patent office can decide. And here there is a clear legal provision and also public policy that whether it's a new and useful invention can be decided only by the state, either directly or through the courts or through its patent officer, and it cannot be left to a private adjudicator. So registration of patent, cancellation of patent is certainly off the limits of mediation and arbitration. But the other commercial aspects, like prosecuting or exploiting the patent, for example, if somebody has applied for a patent or is a patent holder and he wants to license it to somebody for a fee, then if a dispute arises on this transaction licensing agreement or technology transfer agreement, then yes, they can be resolved to ADR and to arbitration, because it does not involve the right of any third party, and the arbitrator does not really have to give any finding whether the patent was validly granted or the patent should be revoked. Similarly, you can take the trademark cases. Trademark also, as far as registration by the registering authority is concerned, we can leave it aside. But similarly, for licensing, for giving the trademark rights to somebody, for ascertaining the damages, for breach of trademark, for valuing a mark, etc., between the private parties, again, arbitration and mediation is acceptable. Not world over, it has always been acceptable. Now it's acceptable in India also. Although we must realize that the bulk of IPR litigation in India today, which takes up the time of court, is mainly at the interlocutory state, which is to get injunction, temporary relief, etc., for breach of trademark as passing off, or even for patent. Now, as far as the interim orders are concerned, even in the arbitration jurisprudence, you have Section 9, you can go to court for interim injunction before the tribunal is constituted or if the tribunal takes too long a time. So to that extent, the jurisdiction of the court for interim orders is also contemplated and also provided in the Arbitration Act itself. Similarly, you take copyright. Now, copyright, you don't have to register yourself. It is not compulsory. So copyright, again, if somebody breaches it or there's an alleged breach, yes, you can have a litigation. But in India, there's a difference of view. In Bombay High Court itself, there's a difference of view. One court holding that yes, it is arbitrable. Other court holding that no, this is not the arbitration, may not be the correct forum. So here also we have to wait either for the Supreme Court or a legislative enactment to change it. See, and similarly, you can talk of Designs Act, Geographical Indication Act, etc. But we must keep in mind that wherever there's a concept of judgment in rem or third-party interest, there, of course, you will have to go to court or a tribunal set up by an express legislation. One reason why in India, arbitration and mediation is not as popular or as widespread as in the Western countries is perhaps the lack of institutional culture in India. Most arbitrations tend to be ad hoc, therefore there is less control, time taken is too high, and the cost also sometimes crosses the people's budget and what they legitimately expected the cost to be. So one way could be, if we can have a system similar to YPO, which is WIPO, which is very popular in Europe, or any such institution, and even promote institutional arbitration, maybe separately, specially designed for the intellectual property sector. Similarly, you have disputes regarding domain name squatting, for which you have international treaties and an international regime also. Many people, they just book a domain name which they know will belong to a big MNC or to a reputed person, and then they try to blackmail or encash this value, which of course is not fair. But the courts in India can take a long time, and especially in this COVID-like situation, it's all the more urgency that we have an institutional arbitration. But then how do we do it? Sitting across this platform, we of course cannot do it. We can only request the government and the ministry to set up more institutions, which actually they have. Most high courts in India today, they have set up the arbitration and mediation cell, and most of them are doing very well. The Delhi Arbitration and Mediation Center is doing very well. The fees is regulated, the time limit is regulated, and even the arbitrators are well selected. The same can be said for other high courts like Chandigarh, Chennai, Karnataka, and Bombay, and most of the high courts where they are doing a good job. So another way could be that for everybody who's interested and everybody who has some right in intellectual property, they can frame a suitable clause referring the disputes to the arbitration of one such arbitration center set up by one of the high courts, so that he can be rest assured his claim can be disposed of expeditiously, also by experts, and also in a time-effective manner. Otherwise, some gray area will remain. And yes, I mentioned the caveat and the rider that for interim applications, interim injunctions, which is very important in trademark and patent violation, the jurisdiction of the High Court will always remain because that is provided in the Act itself. And of course, when you're treating of an international trademark or some violation involving cross-border application, then yes, you may be able to invoke the jurisdictions of the foreign institutional arbitration centers, but they can be very expensive for people who are based in India. So I think this is a gross overview. I do not want to go into the mechanics or specific provision or the specific case law, because then the focus will change. If anybody has any questions, etc., or if anybody wants to have any elaboration on a specific point, then I'll try to give my input.
So we do not have any questions so far, sir. But I would like to ask if, with respect to intellectual property, is there like anywhere any criteria being laid down as to what are the specific matters with respect to intellectual property as well that can be addressed through a alternative dispute resolution, or is it that any of the matters that pertaining to IP, the parties could choose to resolve their disputes through alternate dispute resolution?
Yes, there are restrictions because an IP, as you know, for different intellectual property rights, you have different statutes. For example, for patents, you have the Patents Act. Trademark, you have a separate act. Copyright, again, Copyright Act. For Designs Act, again, you have a Designs Act. For geographical indication, for semiconductor, again, you have separate rights, separate statutes. And also for plant varieties, you have a separate statute. So you have to see each and every statute to determine whether you have to go by court or to the tribunal or whether it can be referred to arbitration. So before an intellectual property dispute arises, we have to see which intellectual property is involved. If it's patent, you have to see the Patents Act to see whether you can go in for arbitration or whether it is mandated that you have to go to the authority specified under the statute. The same thing for each and every different intellectual property right. But as I said just now, if it is only a question regarding payment of money between two private parties, which is like somebody gave a license to exploit a trademark or a patent, somebody did not pay up, or there was a transfer of technology involved, somebody did not pay up, then yes, this broadly can be referred to arbitration, and you can always propose and incorporate an arbitration agreement, arbitration clause in your main agreement so that you have clarity. And here you can also have institutional arbitration, even a foreign institutional arbitration, if the parties so agree and if they can afford the fee. Otherwise, as I said, please avoid ad hoc arbitration because that takes time. That may also not be cost efficient. So better is you have a institution like the institution which are set up by the high courts. That would be faster. But before you can decide, you have to first see what is the intellectual property right violated and what are the provisions of the statute before you can decide to go in for arbitration.
Okay. Uh, Rupali here wants to ask as to which IPR cases are tried under which courts. As you said, that arbitrator can take up the matter. So, like, is there a particular jurisdiction with respect to arbitration as well? Or how does that work out with respect to arbitration per se?
Well, arbitration arises out of an agreement. So any person can be an arbitrator, provided the parties have agreed either to him personally or they have agreed to a specified mode of appointment, or they can agree that a third party may appoint him. They can also agree that they will choose an institution. The institution can appoint him and then conduct the arbitration, or the institution can only appoint the arbitrator and then he can act in ad hoc manner. This is open to the parties themselves. They can choose whatever way they like. And in case they are unable to still decide, then yes, under Section 11 of the Arbitration and Conciliation Act, you can go to the High Court, or where the High Court does not have original jurisdiction. For example, in Rajasthan, in UP, many times the district court has the original jurisdiction. So you can apply to him under Section 11 of the Act, and then he will appoint an arbitrator who can determine the disputes. And you can just keep in mind that under the Arbitration Act, I recently amended, there are certain qualifications which the arbitrator must satisfy, and there are certain disqualifications which should not fall upon him so that the arbitrator can be appointed. If it's a high value, you can have more than one arbitrator. If it's a low value, you can decide that there will only be a single arbitrator. The Act also gives you an opportunity to decide upon a fast track arbitration, which means you don't require witness. You can decide, the arbitrator can decide on the basis of the pleadings and the written submissions, which can be supplemented by oral hearing only to a limited extent. And then the tribunal or the sole arbitrator, he can decide within just 30 days or around that time. So you can also choose this fast track arbitration, and there's also a provision where you can act or authorize the arbitrator to act also as a kind of compositor, somebody who can bring about a settlement between the parties. That's also flexibility the Act provides for you. So if you see the Arbitration Act, there's a lot of flexibility, and so you are not bound by the rigid old procedure, but you can do it very expeditiously and in a fast track manner.
Okay, thank you, sir. We do not have any more questions as of now, specifically related to the topic at hand. So we can move ahead and take any questions that might come up at a later stage, sir.
Yeah. So you want me to wait or?
No, we can go ahead and continue the discussion. And if there are any questions that come up, we can take them up later. So we can discuss the further things that we have lined up.
Yeah, so if somebody is entering into any agreement concerning intellectual property, then apart from those specific areas where arbitration is not permitted, you should be very careful, because arbitration agreement has to be in writing, and now there's a judgment of Supreme Court that if it attacks stamp paper, if it attacks stamp duty, then you have to pay the stamp duty, otherwise it will not be referred to arbitration. The arbitration agreement must also satisfy all the requisite criteria of a valid contract under the Indian law. For example, the parties have to be major. It should be a defined contractual relationship. There should not be any undue influence or duress. There should be a consideration. So considering all this, the arbitration agreement can be incorporated in the IPR agreement. Also, to have clarity, you can also lay down the formula or the eligibility of choosing an arbitrator. Either you can name in person, or you can decide for institutional arbitration, or you can even decide that the arbitrator must have certain experience in the particular intellectual area. For example, it could be a patent attorney, or somebody who has done patent cases, or somebody who knows about trademark matters, etc., so that he can dispose of the cases expeditiously. Or you may decide he should have legal knowledge or experience in that particular area. You can also fix the fees, and if you are choosing for ad hoc arbitration. You can also fix the time limit for completion of pleadings. You can also decide whether you will need oral evidence, whether you need to produce witness, or whether you can decide only on the basis of the documents. Now, more clarity and detailed manner in which you draft the agreement, it will help you later on when the arbitration has proceeded, and then you will not be left to any surprises. So I think these are all matters which you should put in the arbitration agreement, and then you will have a very successful, but I only hope that the dispute does not arise. But if it does arise, you can do it in a cost-effective and time-effective manner. If there's anything more, then I can tell you.
No. So Alok has particular questions with respect to dealing with copyright infringement. When it comes to copyright infringement, does can that be like, how does alternate dispute resolution? How would alternate dispute resolution work in with respect to specifically copyright infringement cases? So if you could throw a little bit of light with respect to that.
Actually, in copyright matters, there is a difference of opinion, as I mentioned in opening remarks, between the Bombay High Court. One bench said that no, it cannot be referred to arbitration. Another bench said that no, to a certain extent, like damages, whether there's a breach or not, whether there was a proper licensing, etc. According to one bench, it can be referred to. So because it's a gray area, I cannot really give you an answer in yes and no, but I would suggest that you proceed with an arbitration. If somebody challenges it, then we can argue it out in court. But most courts now are pro-arbitration, and to the extent possible, they will try to ensure that even in copyright matters, you can go and proceed with the arbitration, except if it involves some other matters of public law, etc. Because copyright is not compulsorily registrable, it's more a question of evidence. And if evidence can be produced, then at least between the two parties, the court can decide whether there is an infringement or not. But again, as I said, this is a gray area, so I will not give you a correct answer, yes or no. But yes, one should take a chance. It is quite possible that the courts will uphold the plea of any party to resolve these disputes through arbitration.
Okay. Thank you, sir. We do not have any questions which are directly related to the topic at hand right now. So yeah, we can move ahead and discuss the other aspects of our topic today, such as
apart from IPR, I think you also mentioned commercial
yes.
disputes. So IPR, if there's no question, and since broadly we have covered, and if anything more I say about IPR, it will be probably repetitive. So if you agree, then I can move into the commercial contract angle.
Sure, sir. Sure, we can do that.
In commercial disputes also, although most disputes now are arbitrable, but even here, courts have still drawn the same line. That is a distinction between judgment in rem and judgment in personam. If there is a commercial dispute which involves, let us say, the question whether you are the owner of a property, whether the title deeds are properly registered or not, then yes, the courts will say this is a question of rem, so perhaps go to the court, either the district court or to the high court. Similarly, there is also a gray area where the questions of fraud, for example, to what extent the questions of fraud can or should be decided by the arbitrator, or it should be left to the high court. Because fraud, as you know, also has a criminal element. And if somebody alleges fraud, and if it is found that a fraud has occurred, then apart from the criminal element, there is a public law element that whether the determination of fraud should be left to a private appointed arbitrator or whether it should be decided by a state appointed courts, etc. But if the question of fraud, etc., are the minor crimes which do not relate to any third party, only inter se between two parties, then yes, the court will be more inclined for the arbitrator to give a finding on that. But again, I said fraud is one area which remains to be a gray area. Then there are some matters where the court has felt that there is a public law element involved. For example, there may be some matter where the court felt that there is a tender involved, or whether there's a kind of a government sovereign right or the government's sovereign duty to its citizens, or it involves matter of high defense or matters which may be partly confidential, partly intelligence oriented. Here again, there would be a gray area that the matter will be more likely decided by the courts instead of arbitrators. Because if it's a matter involving Ministry of Defense, or for equipment or supply of equipment which relates to intelligence or some such sensitive matter, although the commercial aspects are certainly decided through arbitration, but there may be certain material factors which the court will say that it's better you go to the court and not just to an arbitration. There's a computation of damages, yes, it can be decided by the arbitration. And there are many matters in which it is alleged that there is a breach of law, breach maybe of FEMA regulations or the RBI regulations or some other breach of law. But yes, the arbitrator can, at least between the two parties, decide that one party is in breach of law and therefore the necessary consequences will follow, whether he can get damages or whether he is not entitled to succeed in his case. But this, as you know, cannot rest just before the arbitrator, because if there is a breach of law, which also involves filing a complaint before any regulatory authority or before the magistrate, then of course that repercussion will happen. And whatever may be the finding of the arbitrator, that will not be binding on the court to that extent or before the regulatory authority. For example, if there's a alleged violation of let us say FEMA, and the arbitrator holds there's no violation of FEMA, this will not bind the central government or the RBI, because otherwise this will become an excuse for the courts to invoke arbitration and to cover up their lapses before the government authorities. Similarly, if there's any allegation regarding some misconduct which may involve diversion, or malfeasance, or some such law which involves you to invoke the insolvency or the bankruptcy provision, then of course you cannot just go in for arbitration. The affected party can take you through the IBC process also. If there's a question of cheating or fraud or diverting money, then also to that extent, the criminal case or other cases will be maintainable and it cannot be resolved just through arbitration. Similarly, for check bouncing cases, there are many criminal offenses which are not compoundable in the sense that you can pay the money and avoid the other stigma of criminal prosecution or being convicted. But even here, you cannot just say that just because it is compoundable, it has to be arbitrable. Person can file a criminal complaint and then the person against whom it has been filed, he can apply for compounding. You cannot say that you leave it and allow it to go for arbitration. The law is not really permitting that, at least not in India. Similarly, there are many acts which may be a breach of commercial agreement, but which may also involve a criminal element like cheating, undue influence, breach of trust, etc., which again you have to go to the court. If it's a matter which involves a charitable organization or a breach of trust or a breach of some fiduciary duty, then again arbitrator is not the correct forum. You will have to go to a court. If there's a guardian who has misused his responsibility, then again the matter will go to the court. It cannot be resolved through arbitration. So there are a lot of such disputes which we think they are commercial or which should go before arbitral tribunal, but actually it will go only before the civil court. Even in landlord-tenant, disputes regarding the term of tenancy or the quantification of rent or damages or the reimbursement of repairs, this can go before the arbitrator, but not the validity of any ownership of title or the validity of a mortgage, etc. That can only go before the civil court. Similarly, creation of mortgage is a right in rem. There are certain matters which are expressly reserved for DRT. There again, you cannot just simplicity invoke arbitration unless both the parties agree. Similarly, in cases of divorce, etc., to an extent, claim for compensation or reimbursement or alimony to a limited extent, that can go before the mediator or the arbitrator. For the divorce or judicial separation or the custody of child, that per se can be decided only by the family courts or by the court set up under the statute and not by the arbitrator. So these are the general observations even for the non-IPR related matters which concern the courts in a day-to-day matter. Similarly, there are certain statutes where there is a statutory arbitration. For example, in the Industrial Disputes Regulation Act, if there is a labor dispute, there is a statutory arbitration. So you have to go to the tribunal which has been appointed by the statute. Otherwise, the procedure are broadly similar. The same thing is applicable for many other statutes where the tribunal is provided by the statute itself, and the parties cannot vary that appointment of the tribunal or the arbitrator, and they have to follow the same procedure. Now, if there's any other question I can take, but I think it will get a bit repetitive now.
So, sir, one of the attendees has brought to the light that the Supreme Court just a couple of days back came up with a judgment wherein it was a 4-step criteria was given for determining arbitrability of dispute. And the Radhakrishnan judgment was overruled. So, what are, if you would like to throw some light upon that judgment and what are your opinions with respect to that, it would be great.
Although it's a recent judgment, but just to clarify, what the courts have recently decided is not really new. The only difference is the application of that principle to landlord-tenant matters. For all of the aspects which the court has decided, they were decided earlier also, and there's nothing new in this. For example, they have decided that patent, copyright, etc., or the criminal matters, or where their sovereign rights are concerned, they are not arbitrable. This was the position earlier also. Now, regarding landlord-tenant, it was more of a question of application of the principle of judgment in rem and judgment in persona. Here also the courts have said that to the extent the Act provides that all your disputes must be referred to a rent control tribunal, then you have to go to the rent control tribunal. You cannot go before the arbitral tribunal. But if the statute does not mandate that, if it's a normal lessor and a lessee transaction, which is outside the provisions which mandate you to go before the rent control tribunal, then yes, to that extent you can go to the arbitral tribunal, which can also be agreed between the parties. This is the real difference between the earlier case which they overruled and the present case. Because the earlier case said that all landlord-tenant matter, and as if all lessor-lessee matter must be settled only through the courts. The court said no. Even here there is a distinction. The matters which are reserved by statute for rent control tribunals, there you cannot go in for arbitration. If it is not reserved by the statute for a rent control tribunal, then yes, you can go in for arbitration. That is the only distinction. Otherwise, the law is the same as earlier. I hope I've been able to clarify.
Yeah, sure. So, Ankit has a question, not really specifically related to the topic in hand, but it is like, what is the difference in jurisdictional jurisprudence for an appeal in different high courts? For example, in Delhi High Court, I can go to directly to High Court in Delhi, but Bombay appeal, if in case of an appeal, I would have to first approach the district court. So how does that, why is there a jurisprudential difference? Why is there a difference between the way appeals are to be addressed in various jurisdictions? Is there a reason for that, or is that done arbitrarily?
Actually, the real reason lies in our constitutional and judicial history. Most of our courts were set up during the British period, and initially the British set up courts in the so-called three presidency towns, where they did most of the business and where the Britishers are settled, namely Bengal, Chennai, which was then called Madras, and Bombay Presidency. They set up first the Mayor's Court, then the Recorder's Court, and then the High Courts. These High Courts were set up under the charter given by the Crown directly. Now, even after independence, we have not really simplified this procedure, and we do not have a uniform High Court legislation. Although the Government of India passed the High Courts Act, All India High Courts Act, but they did not do away with its historical legacy. So what has happened is, for example, when the Britishers settled in Calcutta, they settled in only a small part of Calcutta, which was Fort William and certain areas surrounding Fort William. This was called the Presidency Town. Now the boundaries have remained the same except for a slight enlargement. The rest of the town of Calcutta, which developed, fell outside the Presidency Town. So that when the High Court was set up by the Britishers, they had original jurisdiction only over this Presidency Town and not over the other area which was added to the municipal town of Calcutta, for which your original site jurisdiction was vested in what were then called the provincial court, and now they are called the district courts. Therefore, you have in each presidency town, you have two hierarchy of courts. One is the High Court, which has jurisdiction over a certain part of the town. Then you have district courts, which have jurisdiction over the greater municipal area of the town, apart from the presidency town. So if a dispute arises within the presidency town, you can go straight to the High Court. If a dispute arises outside this limited presidency town, then you have to go to the district judge. This legacy is actually a historical legacy. Similarly, when the High Court was established, under the Charter, certain rights and powers were given to the courts and to the litigants. For example, if a single judge decided something, there was an appeal provided to the division bench of the same High Court, which is called letters patent appeal, because these courts were set up under charters which were called letters patent. But for appeals which have to come from the district court, the letters patent do not apply. There the right to appeal depends upon the Civil Procedure Code or the Arbitration Act and other statutes. That is why you have this difference in the nature and forum of appeals and also in the pecuniary limits, not only in Bombay, but also throughout India. For example, in Rajasthan, high courts do not have original site. And if you want to enforce an arbitration award, you have to start in the district judge. Same is there in Uttar Pradesh and most other states in India. It's only a very limited number of states which has got original jurisdiction. What I mean is that the high courts have original jurisdiction, which is the three old presidency high courts, Delhi High Court, and maybe one or the other more. So to just answer your question, this is the historical legacy which we have not rectified till now.
Okay, thank you for the answer, sir. So we do not have any further questions. If there is something that you would like to say, you could do that, and then we can end the session. So, yeah, is there something that you would like to say towards the end?
Well, I would only like to say that arbitration is a good remedy. Mediation is even better. But you must be careful how you draft the arbitration agreement. Unless you specify the procedure or the institution and even the fees of the arbitration, how much of the arbitrators, how much time it should take, to what extent evidence should be allowed, you will be taken by surprise and may not be able to limit the time or fees of the arbitration proceedings. The time limit has been fixed by statute, but the statute does not provide what will happen if the time limit is exceeded. The amendment to the Arbitration Act says you have to dispose of the proceedings in 1 year, but even the older Act, 1940 Arbitration Act, provided for 4 months. But what happens if the proceedings are not concluded within that time? Where do the parties go? There is no answer to that. The parties have to again go to the High Court or to the lower court, and they are left high and dry. Therefore, if you provide all these time limits in the agreement, that will help you. And if you choose an institution rather than ad hoc, then that would be the best way. You can easily resolve your disputes to arbitration, and also choose a good institution where you know things will be decided fast and in a time and cost-effective manner. That's my suggestion.
So thank you for joining in, sir.
My pleasure.
It was a great session, and I am sure everybody would benefit from what we talked about today. So this is it. We can end the session now. Thank you for joining in, everybody. Thank you, sir.
Thank you.
Bye.